principle of democracy, in theory, is one person, one vote. But for decades, Republicans have done their best to evade the obligations of providing people with equal representation, purging voters from voter rolls, making voting more difficult, and redistricting seats to make the outcome of elections a foregone conclusion. In purple states like Georgia, Ohio, and Wisconsin, hundreds of thousands of voters were removed from voter rolls in 2019 and 2020. Gerrymandering, the process of drawing district boundaries to favor one party over the other, has warped legislative maps in places like Wisconsin, North Carolina, and Texas. More than half the states in the US have enacted voter ID laws that make it harder for people to vote, particularly low-income voters and people of color. Voter suppression is, in theory, subject to review and reversal by the courts, but the Supreme Court, under the conservative majority of Chief Justice John Roberts, has frequently declined to intervene in blatant cases of partisan voter suppression and has limited the power of lower courts to step in. In 2013, the court struck down a key provision of the Voting Rights Act, allowing states with a history of racist voter suppression to make sweeping changes to their voting laws without obtaining federal approval. In the wake of this decision, many of the states purged unprecedented numbers of voters from their voter rolls, 4 million more voters between 2014 and 2016, the period immediately after the Shelby County ruling went into effect, than they did between 2006 and 2008. The Roberts Court has also declined to interfere with the Florida legislature's efforts to gut Amendment 4, a 2018 constitutional amendment intended to restore the voting rights of 1.4 million people previously convicted of felonies in a state where the criminal legal system had disenfranchised about 1 in 5 Black residents. As COVID-19 makes it harder for people to vote safely, Donald Trump and other Republicans have called state provisions for voting by mail illegitimate, claiming that these provisions enable voter fraud. As the ideological composition of the Supreme Court shifts with the passing of the great Justice Ruth Bader Ginsburg, the door is open for further conservative efforts to limit federal oversight of voter suppression. To discuss the changing legal landscape around voter suppression, we're joined by Jay Willis, Dwight Bullard, and Leah Littman. Jay Willis is a senior contributor for The Appeal, where he covers politics in the Supreme Court. Dwight Bullard is a former Florida state senator and the current political director of the New Florida Majority, a voting rights organization. And Professor Leah Littman is a constitutional law professor at Michigan Law School. Your organization, New Florida Majority, was instrumental in passing Amendment 4. What has happened since voters passed the amendment in 2018?
So almost immediately after the passage of Amendment 4, the legislature went into session under the new governor and decided to impose what we know to be voter suppression, but also a poll tax. For those unfamiliar with what a poll tax is, this was an egregious fee that was tied to voting that was meant to limit the participation of African Americans, especially in the South. That the grandfather clause and literacy test and a number of things were then thrown out by the Voting Rights Act, or at least scrutinized by the Voting Rights Act. So it's very interesting that after the Shelby ruling by the Supreme Court, you see a myriad of bad policies passed by oftentimes Republican-led legislators. In the case of this was a people-led initiative. 65% of the voters approved it, but then the legislature here in Florida decided to impose this poll tax explicitly on those 1.4 million individuals, returning citizens, that would have been positively impacted by the legislation. It in essence requires them to pay all fines and fees that have been accumulated during their time under carceral supervision. And I want to distinguish, because a lot of people oftentimes conflate the notion of restitution with fines and fees. The restitution that courts impose, which is to pay back families or damages that may have been caused by the bad act, that's not it. These are fines and fees. These are accumulated fines and fees put on these individuals by the state on top of the carceral supervision. So if you can only imagine people being charged rent for their time in jail and in prison, that is what's being asked to be paid back. Supervisory fees for ankle monitoring, the fees that are incurred for urinalysis. Those are the kinds of problematic things that oftentimes accumulate and put returning citizens deeper in debt once they're done with their time.
So you've mentioned voter suppression, and you've talked about poll tax. Some of these voter suppression strategies are new, many are not. Can you give a bit more history about poll tax and specifically how these relate to historic efforts at voter suppression, especially in the South?
Yeah, so taking Amendment 4 and what it was meant to get rid of. In 1868, following the passage of the 13th, 14th, and 15th Amendments, Florida adopted this policy that if you committed a felony, you would not have your voting rights restored in perpetuity, indefinitely, right? And so what was subsequently the first felony that they would pass, or created felony, was the felony for vagrancy, just being homeless or being out and about, being a felony, primarily because the newly freed blacks were homeless or houseless. And so you immediately kind of reincarcerate or reinstitutionalize slavery through those policies. But you saw a series of things in states like Mississippi, but also in states in the North like Pennsylvania and others, where you would have grandfather clause, which was basically saying that if your grandfather could not vote, you couldn't vote, or literacy test that they said were universal, but they would ask white participants, what are the first three words of the preamble to the Constitution, whereas they would ask Black people to please say verbatim without stopping the entirety of the Constitution. Then you saw some even more egregious forms and very deliberate. How many jelly beans are in this jar? How many grains of sand are on the beach? How many hairs are on the head of this person? It was all very intentional and very deliberate in terms of trying to stop people from participating in the franchise.
Thanks so much. I mean, I certainly couldn't answer any of those questions. What do you perceive as the direct personal impact on what's happened here? Like, how many people are we talking about that suddenly thought they were going to have rights, don't until they pay this poll tax?
So Amendment 4 was the largest voter expansion since the Voting Rights Act. I want people to understand that. 1 out of every 4 returning citizens or people who had committed felonies, 1 out of every 4 were in Florida that were being disenfranchised. So 25% of the total disenfranchised population of returning citizens were housed in the state of Florida. And what that equates to, numbers-wise, was roughly about 10% of the voting age population statewide, regardless of race. And so you're talking about a significant number of people, 1.4 million individuals that were impacted. There are directly about 776,000 individuals who are going to be impacted by this fines and fees legislation. So you're talking about a significant number of people, as you pointed out from the onset. That's almost 1 out of every 5 Black residents in the state of Florida, ultimately. And so it's sad. It should be illegal, but we're going to do everything we can to fight it.
Thanks, Dwight. I appreciate you giving us that background, and I want to later turn back on what folks can do to help fight it. Before that, I want to turn to you, Jay. Jay, you've written on the Supreme Court's movement away from restraining state-level voter suppression schemes and partisan gerrymandering. How is what we're seeing from the court under Roberts different than previous courts in this regard?
Yeah, I mean, the short answer is it's not really. I mean, to the extent that the Supreme Court was ever a meaningful defender of voting rights, it certainly hasn't been under Justice Roberts or Chief Justice Roberts. And this isn't really a coincidence. Roberts has long been hostile to voting rights, well before he became a federal judge, and to the Voting Rights Act especially, because he's part of this conservative movement that maintains its electoral relevance by strategically thinning out the electorate. So as a young lawyer in the Reagan Department of Justice, Roberts drafted dozens of memos, talking points, op-eds, all arguing for limitations on the Voting Rights Act during one of the reauthorization debates. He argued that violations of one of its key sections should not be, quote, too easy, unquote, to prove in court. Now, former colleagues described him as kind of having had it in for the act, that he was really sort of a zealot for opening the country back up to the possibility of state-level voter suppression. The late Congressman John Lewis testified against Roberts's confirmation in 2005. He said that the country couldn't afford to install someone who, quote, had such a strong desire to reverse the hard-won civil rights gains that so many sacrificed so much to achieve. That Shelby County decision you mentioned, that was like the big decision that gutted the Voting Rights Act, basically by doing away with a formula that determined which jurisdictions were subject to one of its most important enforcement mechanisms. And his rationale was basically that the South was not quite as racist in 2013 as it was in 1964, and that therefore the act was no longer necessary, which is like, sorry, that's dumb, right? It mistakes a solution that is working for evidence that a problem no longer exists. And the late Justice Ginsburg summed this up really nicely. She said, it's like throwing away an umbrella in a rainstorm because you're not getting wet. But Roberts has authored or signed on to a number of other decisions that make this country a little less democratic in one way or the other. Voter roll purges, voter ID laws, partisan gerrymandering. Voting rights during his tenure has been pretty much an unmitigated disaster. And I wish I had like a sunnier outlook to share with you like 5 weeks before the election, but here we are.
Thank you for that, Jay. Now, I'd like to, given what you've just described as the Roberts Court and their history with voting rights, what do you foresee with the appointment of Amy Coney Barrett? If she is confirmed to fill that seat of Justice Ginsburg.
Yeah, I mean, I'd love to be wrong about this, but a 6-3 Republican majority on the court is going to be worse than a 5-4 Republican majority on the court on an issue that Republicans were already bad on before last week. But this doesn't, just to be clear, this doesn't have to do with Judge Barrett specifically. Any Republican judge is going to make this worse. And it really goes back to sort of this existential crisis that the Republican Party has been dancing around for decades. Demographically, this country is shifting towards groups that tend to favor Democrats over Republicans. But instead of moderating its message, the Republican Party has made, racism and xenophobia appeals to those things like really core tenets of its platform, while also trying to box out voters who they fear won't go along with it. Like Trump is a racist, but his presidency and his ascendancy within the party are just the logical endpoint of a strategy that Republicans have been pushing in Congress and conservatives have been promoting in courtrooms for decades. And really, the reason the Roberts Court is so committed to this is that every other aspect of the conservative agenda depends on its success. If you carve out Republican-friendly districts, you get more Republican lawmakers and more Republican chief executives who pass laws, and then more Republican judges to uphold them in court challenges. Being a conservative judge is a little bit like being in a jurisprudential Ponzi scheme almost. Yeah, you'll get a lifetime appointment to the federal bench, but when some of this voter suppression comes up, you better vote to uphold it.
I'm definitely stealing that. Jay, last question before I turn to Leah. What do you say to the folks who say, no, Justice Roberts is more concerned with the legitimacy of the court, and so he will be a stabilizing, influence for, to prevent the other conservative justice to describing exactly what you said would happen?
Yeah, in my view, he's not concerned so much with the legitimacy of the court as he is with the appearance of the legitimacy of the court. It's really useful for a party that is unpopular and an ideology that is unpopular to have this institution that can advance its agenda not by passing laws, but by saying, well, the Constitution compels it. So that's why he is so interested in making the court seem nonpartisan. But in my view, what his decisions have done is advance the conservative agenda on an incremental basis while retaining sort of the appearance of legitimacy to make sure he can continue to do so.
Thanks, Jay. Leah, I'd like to turn to you. I love your shirt. And I'd like to ask you, mail-in ballots are huge in this cycle, both from a voter perspective, from President Trump's perspective and the rules around that have become a focal point for potential litigation given the COVID-19 crisis. The court ruled on one such case in Wisconsin earlier this year. What did the court do in that case, and what does it tell us about how a similar conflict might play out in November?
So the challenge in Wisconsin was actually to rules regarding the state's receipt of absentee ballot requests and absentee voting before or after the actual primary date. So Wisconsin held a primary as well as elections for several state judicial offices as the pandemic was happening in March and April. So several citizens brought a challenge seeking to ask the state to extend the deadlines for receiving absentee ballot requests and for receiving absentee ballots that they would count in that primary election, in part because the Postal Service was overwhelmed by demands for absentee ballot requests and absentee ballots in light of the pandemic. They obtained that injunction from the district court, who determined that given the volume of requests that the state was receiving, they simply did not have the resources in order to process all of the requests that were received in a timely manner to allow the individuals to vote by mail. The Court of Appeals for the Seventh Circuit affirmed that decision. However, the U.S. Supreme Court, by 5-4, with the 5 conservatives in the majority, stayed that decision, thereby leaving in place the rules that said, if the state hasn't received your absentee ballot by this particular date or hasn't received your absentee ballot request by this particular date, you have to vote in person or you don't vote at all. We saw the effect of that ruling when we saw the lines of people who had lined up to vote and exercise their ability to do so in the midst of the pandemic. So that was one such decision. There have also been challenges to absentee ballot restrictions, like in Alabama. So Alabama requires individuals to have 2 signatures, either from a public notary or witnesses, as well as to include a copy of their government-issued photo identification with an absentee ballot request. Obviously, those restrictions are extremely onerous during a pandemic when you can't exactly go to Kinko's. However, the district court found that those requirements unconstitutionally burden the right to vote. The U.S. Court of Appeals for the 11th Circuit agreed. Once again, the Supreme Court disagreed and allowed the state to enforce its restrictions on absentee ballots pending a full trial.
Thanks, Leah. When it comes to absentee ballots and mail-in ballots, what keeps you up at night? Like what scenario do you really worry about playing out in November?
Many different scenarios keep me up at night, depending on which night we're talking about. So one is potential challenges to the counting of ballots after Election Day itself. Again, given the volume of requests for absentee ballots, as well as the stresses that are being placed on the Postal Service by this administration, there is almost an inevitability that states in swing states will be counting ballots well after Election Day. We need to be prepared for that possibility, and we can't assume that it is necessarily illegitimate when they are doing so. And yet this president, as well as the Republican National Committee, are attempting to delegitimize efforts to count votes after Election Day, even though that it is inevitably required when you have people voting absentee in states that don't allow the counting or even processing of ballots before Election Day.
Thanks so much. I'd like to shift topics a little bit and talk about gerrymandering and redistricting after the census. What can we expect to see as a result of the Supreme Court's decisions to not intervene in blatantly partisan redistricting efforts? What's your prediction?
So I think 2 consequences from that, and then there are separate issues with the census. So as Jay mentioned, the Supreme Court held that federal courts are not able to intervene to strike down partisan gerrymanders where legislators draw districts that favor one political party versus another. So where you pack all of the Democrats into a few districts and therefore leave Republicans with a majority of districts with comfortable margins, that allows Republicans to retain political power at the state level, even if they don't necessarily win a majority of the votes. In Rucho versus Common Cause, the Chief Justice, writing for the 5 conservatives, said federal courts can't invalidate those partisan gerrymanders. And so what that allows state legislatures to do is to encase themselves with the protections of partisan gerrymandering from democracy. The last time states drew districts, they didn't know whether partisan gerrymandering could be remedied by federal courts. And so they were at least a little bit nervous about being too ostentatious about what they were doing. And yet you still had states like North Carolina drawing districts where 9 or 10 are safe Republican and only 2 are Democrats. And so this time around, the gerrymanders could get even worse, and they're already really bad. Another problem is that partisan gerrymanders can operate as a defense to claims of racial gerrymandering, because what will happen is you will have states say, when a group of voters say, you attempted to dilute the voting power of racial minorities, the state will come back and say, no, we were just trying to advantage one political party versus another. And given that the court has now said partisan gerrymanders aren't remedied in courts, that's going to create real problems for plaintiffs who are alleging racial gerrymandering as well.
Thanks so much, Leah. So this is terrifying, all of it. Dwight, I'd like to turn back to you and get us back to how people can get involved and stop some of what is happening, at least in the next couple of months.
Well, of course, being a voting rights organization, we're always going to say vote. Encouraging folks to get involved. But for the fines and fees issue specifically, got to give a big shout out to Desmond Meade, who was kind of the brainchild behind Amendment 4 here in the state of Florida. And his organization, the Florida Rights Restoration Coalition, has been spearheading a fines and fees portal that exists on their website. So I would encourage folks, if you want to eradicate the fines and fees, these so-called fines and fees that these folks have accumulated, you can go to their website, which is floridarrc.com. That's floridarrc.com to donate. You may have read recently that the former mayor of New York, Michael Bloomberg, has helped raise a significant number of funds to help eradicate those fines and fees. But going back to the notion of voter suppression, the state attorney general is now trying to investigate how a billionaire by the name of Michael Bloomberg was able to raise $16 million, which is a very interesting thing to even pose that question. How did this person, who could have clearly cut his own check, accumulated this kind of money, and whether or not that was legal for him to do that. But it's embarrassing that we're standing here in Florida in a space where people, where the will of the people was exercised in 2018. We tell people to vote all the time. 65% support something. The legislature goes behind and does something egregious. And then the administration is now trying to uphold such a problematic entity, even when everyday people are trying to satisfy that. But to that end, there were still some 44,000 individuals who've donated to that cause thus far in individual donations. Everyone from the likes of LeBron James and John Legend to, the average everyday citizen, to the tune of $5 or $10. And so I'd encourage anyone who wants to help, any immediate help with that, because our voter registration deadline here in the state of Florida will be Monday, October 5th. And so we want to make sure that all those folks that can participate in this upcoming election have the opportunity to do so.
And we definitely want to vote to support those folks' right to vote. So anybody who can get involved, we really appreciate that. And following up on that, you mentioned the will of the people, and this is, any of you can answer this. What are we going to do about this? We're facing a real possibility that before the election, Donald Trump gets his nominee through. What are we going to do to protect voting rights? What are we going to do to address gerrymandering in this country? And this is both, short-term and long-term solutions for people that want to get involved and want to feel that there's actually hope to change these systems.
Well, I'll jump out there first, just because we've invoked the name of John Lewis a few times. So I'd encourage everybody to get into some serious good trouble between now and November 3rd, even post November 3rd. Organizations like ours are always looking for volunteers to do work on the ground, and that is everything from engaging with folks directly around the election, but also uplifting some of the core values and principles that we all hold near and dear, like dealing with the notion of climate change, or dismantling systemic oppression through the criminal justice system. All these things need our attention and our help. And so I would encourage folks to join us and get in good trouble.
Thanks, Dwight. What do you think, Jay?
I mean, there's a bill in the House right now, H.R. 1, the For the People Act, right? It passed the House in the first couple weeks of this current Congress. It would make Election Day a national holiday. It would use nonpartisan commissions to draw districts, and it would institute national automatic voter registration. And it passed, but it's not getting anywhere in this Senate. If the Democrats were to take a Senate majority, and just hypothetically speaking, they were to abolish the filibuster, they could expand the court, but also they could get some voting rights legislation done. And I want to return a little bit to something that Leah mentioned about the Rucho decision, which is that in his opinion, Chief Justice Roberts, he said, partisan gerrymandering is a political question that the federal courts can't take up. But at the end of his opinion, he also said, well, this doesn't mean we endorse partisan gerrymandering. Obviously, there are ways of addressing it. And he said, state legislatures can pass laws. Congress could pass a law prohibiting it, which sounds great until you remember that these legislatures that you'd be counting on to protect people's voting rights are the same ones that draw the maps, that do the partisan gerrymandering in the first place. Saying, oh, Congress, it's Congress's job to do this. It's just kind of the formalistic nonsense that pretends that Mitch McConnell doesn't exist. Congress can barely be bothered to pass a COVID bill during the pandemic, right? But we're going to say that he's going to be the one in charge of expanding voting rights? Come on. There's a relationship between legislative voter suppression and judicial endorsements of that voter suppression. They enable each other to remain in power, which is why Roberts and company feel so passionately about this in the first place.
Thanks, Jay. Leah, how are we going to build institutions that protect all of us? What's the future?
I wish I had one solution to offer, but I think I would echo, what both Senator Bullard and Jay have said, which is you need both state and federal level efforts. At the state level, you need the sort of state reenfranchisements efforts that admittedly Florida is trying to stymie right now. But that was a movement that passed at the state level in a state that has skewed red. And so that's one tactic, related to gerrymandering. You can also try to adopt constitutional amendments that provide for independent districting at the state level, even if it's not mandated at the federal level. Although, of course, there's a possibility that the Supreme Court is going to invalidate that. But I'll put that to the side. But also, the federal legislation that Jay mentioned, voting needs to be made easier. There need to be uniform, accessible rules, and that needs to be a core focus of a future Democratic Congress and presidency.
Absolutely. Well, I know you all are busy and have to get back to work, but I appreciate your time. It's clear we have a ton of work to do to protect the fundamental right to vote. And as Dwight said, it's time to get into some good trouble. So looking forward to that in the coming weeks. And thanks everybody for joining us for the briefing. Follow Appeal News on Facebook and The Appeal on Twitter for the latest news, and also check out The Appeal, the briefing podcast, because we're going to be streaming immediately after shows will be uploaded, so you can check us out on The Appeal podcast as well. So appreciate it.